because what I see so far, they have no enforced Russian judgments based on the Lugovoy law. I'm aware of about a dozen proceedings started worldwide. Mostly that's about a Google case. So we brought applications in Serbia, Egypt, Kazakhstan, South Africa, and some other countries, and so all these proceedings are still pending. Only in South Africa, some partly success. Yeah, so the cases are frozen, but the judgment is still not recognized yet. So we will see. So in here, what I see, in Kazakhstan, at least the application failed in that was Roschem Alliance case. So the first instance court and the appeal court of Kazakhstan, they denied this recognition, but on quite vague reasons. So again, there is no full stop in this story. So I believe that the main threat and the main difficulty in such proceedings is that what would be the ground for denial of recognition? Yeah, because in most countries it's a breach of public policy, and application by a Russian court of the Lugovoy law, is it in a breach of, say, Chinese public policy, or I don't know, South African public policy, or Indian public policy? That's a big question. Yeah, because most likely not. Because if it's like exclusive, for example, jurisdiction of English courts, and the Russian court accepted its jurisdiction, and when such judgment is brought to England for recognition, that would be definitely denied because of breach maybe of English public policy, because English courts had exclusive jurisdiction. But if such judgment brought to another jurisdiction, so there is a big threat that just no grounds to deny its recognition. And the second one, you, Nikolai, already mentioned, so maybe, and you, Igor, mentioned like unfair trial or a breach of natural justice. So for this one, so maybe it's just a challenge of jurisdiction is not enough. So when you should show that you dispute on the merits, and the Russian court just ignored all your arguments. So this might be deemed as a breach of natural justice or unfair trial, yeah, because Russian court treated you as nothing. So we will see. But thank you, Nikolai. So let's make a small research right now. So, for example, you see that there are two grounds to recognize the Russian judgment abroad, relevant to our topic today. So the first one, that was like Lugovoy law. That's why Russian courts accepted its jurisdiction. Or alternative ground, it is just bankruptcy proceedings, and that's why Russian court has exclusive jurisdiction over a bankruptcy case. So if you are a judge in your jurisdiction, so if Russian judgment was based on Lugovoy law, would you recognize this judgment? So please raise your hand if you recognize it. What jurisdiction? All right. Okay. Please take my.
I'm not of the opinion that it should be in all cases unlawful, in a nutshell. So I'm coming from Europe, as you know, so in our jurisdiction, there is no way to get this recognized. So, but in principle, I think, I won't say 100% it is unlawful per se, but it's my personal opinion.
Thank you. Okay, and let's now imagine that the case like the second scenario, when it started with the Lugovoy law, and when it led to bankruptcy of foreign companies subsidiary in Russia, for example, or foreign companies itself in Russia, yeah, because there are some links to Russia. And so it's a judgment brought in a bankruptcy case, and then it's the judgment creditor is trying to recognize and enforce it abroad. So you are a judge in your jurisdiction. Would you recognize this judgment? Please raise your hand who recognize it.
Well, I have different things. I've just been hearing. My name is Abdurrahman al-Sharia. You can call me Abdel. Oleg, Igor, Maxim, and Nikolai. You've been saying challenging jurisdiction and court, the Russian court claiming jurisdiction, non-friendly countries. And I think the solution is political, not legal. So you've already asking rhetorical questions which you already know the answer for. The solution is political. And I think you don't need to wait for the reciprocity that you mentioned. Signing judicial cooperation treaties with countries where you want to execute the Russian judgments is the solution for whatever you're facing right now. I think also if you are talking about foreign companies leaving Russia or having issues with doing business with Russian companies, you forgot the hostile takeover of McDonald's in Russia. I don't know what is the name now, but it's tasty and that's it, something like this.
Tasty and full stop.
Exactly. Yeah. So you can't claim that you are the underdog here because you've done whatever possible you can do in Russia when it comes to foreign investors. But in order to fix or trying to help or finding a creative solution for what you've been facing, whether you want to execute Russian judgments against Google in Egypt, South Africa, or whatever, I think you need to have a meeting with the Ministry of Justice in Russia, like the top law firms will go there, have a meeting, and try to discuss these judicial cooperation treaties with countries where you want to execute your judgments. Better than advising your clients to change the ultimate beneficial owner. So we don't need to have the nationality of the company. It's a Russian company, but for example, having the ultimate beneficial owner will be Russian. However, the company is registered in Panama. So Panama is neutral, so you can use this in your favor. Somehow, these are types of ideas or solutions for your situation, but you already know the answer. It's political.
Thank you very much for your feedback. Just two comments in this respect. First of all, we are focusing on representing of the foreign clients in Russia and abroad. So it will be quite strange to suggest our clients to have a meeting with the Ministry of Justice of Russia and discuss those issues. The second point is that, of course, the eventual and ideal solution for all of this stuff is some treaties, but it may be quite hard to motivate public bodies to conclude any treaties. So we have to face the reality as it is, and we have to find the solutions for our clients, and we have to consider the potential threats for our clients abroad, not only in Russia, but here in UAE as well. And that's what we're talking about here now.
Yeah, and well, the treaties, it takes like ages, to ratify any international treaties, and the situation is developing rapidly and right now, so there is no time to wait. Sorry, you had a question.
Yes, thank you very much. Just an additional comment, and maybe this helps a little bit to understand the answer to the previous question from my perspective. Anna Zeitlinger, Lansky, Ganska and partner from Vienna, an international law firm with a headquarter in Europe. from our perspective, we're looking at this matter because we are sitting a little bit on a different side of the barricades from what your colleague just said. We sit in the situation where we defend the interests of the Russian companies in Europe who are facing expropriation. And the situation that we are seeing right now is that Europe is, I won't say full of piggy box, but it's quite substantially in each country of the European Union, there are some remainings of assets of Russian companies hostilely taken over by the government, taken under administration, or forcibly sold to other local players. So we have the state who has benefited from the situation. We have local measures taken in access to the European law. And we have local parties who benefited and has taken over the assets of Russian companies. So this is a different situation. And we have the shareholders and mother companies sitting in Russia still and observing the situation from abroad, having no possibility to impact. And of course, considering this different perspective, you can see Lugovoy Law and the other options and opportunities provided by the Russian legislator as a hostile act, of course, towards the European companies, because certainly it provides a certain means to make it unjust in another way. At the same time, for some companies, it provides a counterbalancing possibility and a solution to find a judgment to combat actually the unjust behavior of the European counterparts and the European regulators in turn. And this gives an opportunity in going abroad and then seeking the recovery abroad, be it through the perspective of Lugovoy Law, although of course it's now prohibited and penalized under EU regulations, so there are limited opportunities to do so. But the bankruptcy is something which might be a creative approach in my perspective, and maybe a tool to help to seek the recovery through also other jurisdictions. But of course, there are a lot of prerequisites to keep in mind. What I just want to say is that it's not that black and white. It very much depends on what is the perspective of the client you represent. And certainly, there are situations where the judgment should not be recognized because it's unjust and a violation of procedural rights. On the other hand, it's an important counterbalance, and the judge also in other jurisdictions can keep that in mind and consider. I think it's not illegitimate.
We are not talking about the politics here, and we are not ready to say that this is black part or this is white part. We are talking about the risks of the particular entities posed by the situation and potential steps to prevent those risks. We are not saying that those companies are good, those companies are bad. And from the practical perspective, I understand your approach. The problem is that I suppose that the courts in UAE as well should not say that the state is equal to the entity from the state, and that behavior of the entity is caused by the state of this entity, and that the entity may be punished for the behavior of its original state. So that's it.
Thank you. So